Hi, we're with Southern Comfort Marijuana Clinic. Thank you for joining our Weed Talk.
Where we talk weed.
Hi, everybody. I'm Georgia with Southern Comfort Marijuana Clinic. Thank you for joining our Weed Talk.
Where we talk weed.
Today, we have two very special guests with us. We have Brett McCain, the CEO of Southern Comfort Marijuana Clinic, and Shelby Roberts, the founder of the nonprofit organization Operation Green Veteran. And today, our topic is regarding gun laws and having your cannabis card.
Very cool. Thanks for having me.
Of course. Thanks for joining.
And I love the slogan, "Weed Talk, where we talk weed."
Catchy, right?
Very catchy.
Favorite slogan. Love
Yes. So one of our most asked questions that we have from patients and potential patients is whether you can have your cannabis card and still have your concealed carry permit. So Brett is here to elaborate on that.
Very good. Thanks for having me. Yeah, I think the first thing to recognize with the gun and laws in general is like we're not attorneys, right? And people, when they are concerned about risk and liability, they consult the appropriate professional. But in my opinion, I've tracked this very closely, and I don't see any correlation between the medical marijuana statute and the concealed carry statute. Because they're both Florida statutes, and there's no conflict in those. I think what often gets misinterpreted in the public is a federal statute is in conflict with the state statute,
Right.
if that makes sense.
It does.
And that doesn't apply to the concealed carry because that's a state statute.
Okay.
But y'all mind if I give you a little history of this? Because
Please.
Go for it. Take it away.
I think the most important thing is to understand the construct of the laws that are applied here. The first one to understand is a federal statute. It's a Controlled Substance Act. It was passed in 1970, which was really passed as a result of a Supreme Court case, I believe Leary versus United States in 1969, in which it ruled that the Marijuana Tax Act in 1917 was unconstitutional on grounds that it violated the Fifth Amendment, the right of self-incrimination. So already ingrained in the marijuana law was a little bit of nefarious intent there to require people to self-incriminate themselves.
Right.
And the Supreme Court upheld that in 1969. So as a result, the following year, Congress passed the Controlled Substances Act in 1970 to eliminate that conflict. So they repealed the Marijuana Tax Act of 1917, replaced it with the Controlled Substance Act of 1970. In that act, there was, it defined 5 schedules of drugs. Schedule 1, y'all are familiar with this, Schedule 1 through 5, 1 being the most dangerous drugs and 5 being the least dangerous drugs. And in there, they gave 3 criterias, really. Criteria is what is the potential for abuse of these drugs, how addictive are they, and is there an acceptable medical use for them. So Schedule 1 drugs, like ecstasy, LSD, I believe even heroin is in there. Right, marijuana is also in that, and part of the requirement of Schedule 1 drug is that it has no medical use, right? Which now there's more than half the states in the United States that disagree with that.
Right.
And really, it's a Controlled Substance Act that is outdated and antiquated and needs to be amended, if you will, to resolve these conflicts of statutes between the state level and the federal level.
Well, that's so wild to me that cannabis is a Schedule 1.
Absolutely.
Substance.
I will never fathom that.
Yeah.
I can't get past it. So hopefully something's changing very, very soon.
And what's also interesting, when you look at the Schedule 2 drugs, you have fentanyl, you have Oxycontin, which we've had 2 epidemics in our lifetime with those 2 drugs.
Right.
They are considered to have at least some medical use, right? But marijuana is not, according to the federal government. So yeah, I think it's just dated and antiquated.
I agree.
The next thing to understand, the next statute, if you will, is the Constitutional Amendment, Amendment 2, that passed in November of 2016. That amendment, the reason why I think it's important, and I have a piece of paper here if y'all don't mind, I wanted to read some of the statute, which I think is important. Article 10, Section 29, subsection A1 reads, "The medical use of marijuana by a qualifying patient or caregiver in compliance with this section is not subject to criminal or civil liability or sanctions under Florida law." Right? So that's a constitutional amendment to the Florida Constitution that says there will be no civil nor criminal liability under the Florida law.
Right.
Okay. So the next one is they came back after that, and I believe it's statute 381 and created the medical marijuana statute, which is what the Southern Comfort Marijuana Clinic operates under, and the marijuana dispensaries and all that operate under that statute. And then the third Florida statute is the concealed carry permit, which that vested the authority under the Florida Department of Agriculture and Consumer Services to issue the concealed carry permits. And recently, I think this summer, our commissioner filed a lawsuit against the federal government.
In 2019.
Oh, was that 2019? I'm sorry.
Correct.
There you go. Filed a lawsuit against them, and I don't think that has been heard yet, if I'm not mistaken.
I don't think so.
I don't think so either.
I haven't heard any updates on that.
So that concealed carry statute is statute 790, and that's the one that y'all constantly hear in the clinic, right? That, hey, I can't have my concealed carry permit and my medical marijuana card. Well, those are both Florida statutes, and the constitutional amendment says, hey, as long as you operate under the medical marijuana statute, you shall not have no civil or criminal liability. But just to expand that, there's another federal statute that I think gets confused for the concealed carry statute, and that's the Firearms Transfer Form, the ATF Form 4473. And in that form, that's applied when a licensed FFL dealer, so federal firearms licensee, when they go to transfer or sell a firearm to a member of the public, right? So that you have to fill out this form, and there's a bunch of questions on there. And in those questions, it's under question 21, subsection E. It has in there about, do you use any controlled substances? And I believe it says, are you an unlawful user or in possession of a controlled substance listed on the Controlled Substance Act, right? That's where it's in conflict when you're going to purchase a firearm from a licensed dealer. To my knowledge, it does not affect if you go to purchase a firearm from a private citizen. They're not required. They're not held to the same requirements as the licensed FFL dealer. And there's no federal firearms transfer form and then background check and all that stuff.
Right.
That comes into play. So I believe that is an avenue for people, but that's where the conflict exists, is the medical marijuana statute and the federal firearms transfer form statute and the controlled substance statute.
So a licensed dealer for a firearm would be like Bass Pro or Lotus, for an example.
Absolutely.
Correct.
Okay. And then, so what about gun shows? Like, what are those licensed dealers, or would that be similar to like a citizen sale?
In my experience, there's both. There's licensed dealers, which are typically the vendors of big booths and all their merchandise on the tables and stuff. Those typically require a license. And in fact, if you're a business, a commercial entity, you have to have a license if you're going to sell a firearm. If you're a Brett McCain or a Georgia and you're trying to sell a firearm from your possession or your home, you're not a commercial entity, you're a private citizen. And typically you'll see those guys walking around the show. They'll have a firearm on their shoulder or something, and a little sign on their back saying $500 or something like that.
Okay.
That they're trying to sell their merchandise there.
Okay. Are there any laws that you're aware of that pertain to having your gun and your marijuana on you at the same time? Because I know, like, with your concealed carry, like, you shouldn't have that, like, in a bar or something like that. I wasn't sure if there was a law in existence that
it's a really good question. I don't know of any law that mentions both, right, in contrast, but when you read the two statutes independently, there are limitations, right? There's typically limitations in all laws. And you already mentioned, like, the concealed carry, there's certain prohibitions from carrying into certain governmental buildings and stuff. Coincidentally, I believe you can carry it into a bank, but not a governmental not certain governmental buildings where, like, legislative hearings are ongoing and stuff like that. And then also with the medical marijuana statute, there are limitations on the use as well, like in public, right? You can't consume in public spaces and stuff like that. So I'm sure if you overlay the two, you'll find, like, an Venn diagram, you'll find areas where they overlap.
Okay.
But I've never seen anything in one specific law.
I haven't seen anything either. And I think it would kind of apply to, like, the same rules as if you were driving around with, like, medical marijuana. let's say a cop pulls you over and he smells it, he has the right to ask you if you have a card, and then at that point he can determine whether or not you're under the influence.
Mhm.
So,
I think when you look at the what do they call the roadside sobriety tests or whatnot, where they make you walk a line and all that stuff. I mean, that's supposed to be scientific if it's held up in a court of law, right, as
Mhm.
evidence. And if that is to determine your inebriation or not, right, I would think a similar scientific testing can be applied to marijuana. And in fact, I would think it'd be the same. Right, because
Mhm.
you need to react well,
Mhm.
right? React
Mhm.
in a certain time frame
Yeah.
and stuff like that. So to me, I think the same science can be applied.
yeah, definitely.
I think another thing that's often conflated out there is that if you are in the medical marijuana registry, that doesn't qualify you as an unlawful user, right? Just because you've been qualified for the use doesn't mean you're an unlawful user,
Right.
right? If you're a caregiver when you're transporting, maybe according to the federal statute, you could be. But I wouldn't qualify you as an unlawful user because you're not consuming, right?
Right.
Isn't that the use? So I think there's just some things that are often conflated or misrepresented, if you
Mhm.
will, in public conversations.
I agree. Another question that I get asked too, which I need to look up, is if I have my weed in my car, do I need to keep it in a certain spot? So I know, like in Michigan, for example, you need to have it in a lockbox
Hmm. I didn't know that.
Yes.
in the trunk,
same
I
thing,
believe,
Same thing
or
it
in your glove box.
pertains in the state of Florida. I don't think it needs to be locked. I think it needs to be without arm's reach.
Okay.
So without arm's reach, and whatever container you have it in, you can switch containers. It just has to show your prescription and then the harvest date sticker to that. Everybody loves to rip off.
Mm-hmm.
I'm like, no, keep that sticker
It
because
says
that's
your
your
doctor, your
receipt. So like, there's
name.
two separate ones. The harvest one is like says what strain it is, what the
Mhm.
date is,
Right.
when it was harvest processed, whatever. They can backtrack that. So God forbid your
Yeah.
name comes off your sticker. You can be like, no, I have this, I purchased this, and then they can pull
Mhm.
it up from there.
And it isn't the same true for medications, like
Yep.
your traditional
I'm
medications.
pretty
You're not
sure.
allowed to
Really?
drop them in a Ziploc
Mhm.
bag,
Oh yeah, yeah.
Mm-hmm.
right? And carry them around because that's easier.
Mm-hmm.
They have to be in the original container where it can be identified by authorities, right, as it
Yeah.
is what you claim it is.
Exactly. So you can totally switch jars. You just have to have your sticker on you, or at least keep the original container in. Because like I buy my weed in bulk, and I like to put it in a giant mason jar. I just like having it in glass better than plastic, and I'll just stick my stickers on there, or I'll have the container inside with it.
Dr. McKean has recommended too taking the stickers and keeping them on like a flashcard,
That's a good idea.
and just like how you do with like your
That's a really good
registration sticker, just keep stacking it on top of there.
idea. It's genius. I didn't think about that. I'm like, oh, that's actually
Sometimes
really
you have to
good.
just baffle them with TMI. That is true.
Yeah. Well, thank you so much, Brett, for joining us today, and
Yes.
Shelby,
Thank you.
stay tuned for our next Weed Talk.
Where we talk weed.